Good morning. Actually, one of subscriber friend wanted to know how to drop cost proceedings to quash certain complaints or prosecution or FIR. Before that, I would like to refer this judgment AAR 2021 Supreme Court 5626 Dale de Souza vs. Government of India, wherein a Minimum Wages Act prosecution was initiated. Therefore, because of certain violations, that complaint ought not have been taken on file for issuance of process under the provisions of section 200, 190 class B. The position was quashed. So you go through the judgment wherein you can get so many technical points in respect of so many other criminal act offences like Dangerous Drugs Act, Provident Fund Act, that you have to go through that. Here, actually, how to draft criminal cost proceedings. First, you must understand that this cost proceedings, 482 CRPC, is another form of writ of certiorari. Certiorari means check the correctness of on face of the records, whether everything was correctly passed within the jurisdiction, power, limitation, etc., etc. Like that only, under Criminal Procedure Code, the High Court, being a head of the state judiciary, can call for the records, check whether anything was correctly followed or not. Then that is so. Number one, FIR, if registered, that can be quashed if the allegations in the FIR apparently did not disclose any offences or did not disclose offences with the required necessary ingredients for that particular offence to register the FIR, or if the offences discloses only cognizable offence, non-cognizable offence, then the court can interfere because there is violation of 154 CRPC. The next question arises issuance of summons after filing charge sheet, final report. Then you can again challenge on the ground that the taking cognizance under section 190 read with 200 CRPC, the court ought to have applied their judicial mind, and because apparently there are certain violation of the act, rules, etc., by filing final report or charge. For IPC offences, you can very well apply all the grounds when you try to file cost proceeding for FIR. Like that, on apparent face of final report, there is absolutely no allegations to take cognizance for that specific offence for which you are answered to summon. This must be the ground. But suppose charges are framed, then you have got an alternative way of revision. So after framing charge, cost proceedings may not be correct proceedings under 482 CRPC. Your way of challenging that must be 397. So that is most important. After commencement of trial, there will be absolutely no cost proceedings except delay or guidelines of Supreme Court about certain fixed period of delay. The matter may be quashed, or else compounding the offence. If suppose subsequently even the offences are not compoundable, there is some compromise affected, matrimonial dispute. For all this, Supreme Court time to time giving certain guidelines and ratios. Based upon that, you can quash that proceedings also. Okay, how to prepare? In the High Court of Judicature, Madras, criminal inherent appellate jurisdiction. Criminal appellate inherent jurisdiction. You can tell that. Criminal OP of 2022 against, you mentioned in between against FIR number or CC number on the file of so and so. Then the name of the petitioner. A petitioner is an accused. What is the number of shown in the FIR or charge sheet, A1, A2, whatever it is, versus state represented by a particular police officer. You kindly go through the final report. Actually, who filed the charge sheet, whether sub-inspector or inspector or AC, he should be implemented as necessary part. Then, because of time to time victimology has been introduced, you have to implement complainant also or victim. Victim, as defined under Code of Criminal Procedure. If somebody is died, is dependent or relative, or somebody is insane or not all right, somebody else can be the informant or the complainant. Then he should be implemented as necessary. Then you have to state that petition under section 482 CRPC to quash the proceedings of FIR or quash the proceedings of charge sheet, whatever it may be. Then next, the petitioner above named begs to state as follows. Number 1, long cause title. The petitioner is Sri so and so, son of so and so, Hindu or Muslim or Christian, aged so and so, residing at so and so. Thereafter, subpara, the address for services on the petitioner complaint is that of his counsel's name and so and so, 14%, that is not. Then the first respondent is state represented by Inspector of Police or Sub-Inspector of Police, Assistant Commissioner of Police, and so address. Then the address for services and the respondent for the service of summons and notices is that as cited above. Same with the respondent. Thereafter, what you have to say, you have precisely state certain facts which warranted the prosecution be initiated against. You have to say that you are practicing or whatever it may be, and that due to, or if you do not know why this case has been, because of your political activity, because of your professional activity, the respondent lodged a false FIR, the respondent lodged a complaint, and subsequently, without a proper investigation, they have filed a final report. If you are seeking for that, precisely you have to state with chronological effect. Thereafter, you have to say the final, the lower court. Then you have to state that is the cause of action. If it is only FIR, you have to state that the respondent, first respondent police, registered an FIR for alleged offences and so on so at the instance of the second respondent without following mandatory provisions of the CRPC. That is enough. Or if the charge sheet is filed, the first respondent at the instance of the second respondent filed the final report without following proper procedures contemplated in the Code of Criminal Procedure, and the learned 15th Metropolitan or the learned is second Metropolitan Magistrate taken, or learned Judicial Magistrate taken the final report on file and given cognizance for the alleged offences so and so, and issued some process of issuing summons. Thereafter, it is therefore the petitioner have no other alternative than to file this petition under section 482 CRPC to call for the records in FIR number so and so on the file of so and so, or CC number so and so on the file of so and so, or PRC number so and so on the file of so and so, and to quash the same on the following among other grounds. Number 1, first, if it is FIR, you have to state that the registration of FIR by the first responder at the instance of second responder is illegal, contrary to the Code of Criminal Procedure. Thereafter, again, if it is final report, you have to state the taking cognizance of CC number so and so by the learned magistrate for the offences so and so, and issuance of process to the petitioner is against law and contrary to the Code of Criminal Procedure. Thereafter only you have to state the apt and vital grounds. Number 1, that even on apparent face of the records of the FIR did not disclose the offences as alleged, as mentioned in the FIR. even on the apparent face of the records, final report in CC number so and so, there is absolutely no allegation against the petitioner. All this, whatever the other grounds you are, thereafter you have to state all these things, and you have to, because of subsequent development, you have to state that this is the first criminal petition filed to quash the proceedings. No other petition is pending before any other court. If you would have filed a discharge application before the court, and then you have to rush to the court, that is not proper. Thereafter only, it is finally you have to state, it is therefore prayed that this honorable court may be pleased to call for the records in so and so FIR or so and so CC under so and to quash the same, and thus render justice. That matter so and so affidavit need not be filed. But for dispense with the appearance of petitioner, or if you want to stay up all further proceedings, there should be some affidavit. You have to say criminal MP of 2022 in criminal OP number so and so. Again, that everything should be followed. What against CC number or FIR number so and so. Then petitioner accused versus respondent complainant. Then respondent de facto complainant. Then you have to state affidavit that I am so and so, do hereby solemnly affirm sincerely state as follows. Then again you have to precisely state what are the circumstances which warranted the filing of charge sheet or FIR. State some reasons, biased reasons. Then it has been taken. It has been taken on file, or the respondent registered the FIR. Then you have to state that by challenging the order, I preferred criminal OP so and so to quash the proceedings, and on the strength of grounds of quash proceedings, I am entitled to quash the proceedings. Then I further submit, unless and until all further proceedings are not stayed, or if the grant of stay of all further proceedings in FIR number so and so or CC number so and so, I will be subjected to irreparable loss and irreparable loss. Then next you have to say that since there is no possibility of hearing the main criminal OP, the balance of convenience is in my favor. Therefore, interim stay may be granted. Then finally, you have to state it is therefore prayed that this honorable may be pleased to grant ad interim stay of all further proceedings in FIR number so and so or in CC number so and so on the file of so and so, pending disposal of the criminal OP, main criminal OP, and thus render justice. The same prayer you have to say, the affidavit, you have to say petition and section 482 CRPC for grant of stay. For the reasons, you have to simply say, for the reasons stated in the accompanying affidavit, the petitioner accused prays that this honorable court may be pleased to grant ad interim stay of all further proceedings in FIR number or CC number so and so on the file of so and so, pending disposal of same prayer dated at Madras counsel for the petition. This all. Again, for dispense with thing, you have to state, as stated in the affidavit for the grant of stay, you have to, instead of giving reasons for grant of stay, you have to say that I am sick or I am residing over, I am busily engaged in my profession, there is financial and other difficulties to attend the court periodically. Therefore, you have to say that my periodical appearance in CC number so or FIR number so may be dispensed with the pending disposal of it. This is the way of. Then again 482 petition for dispense with the periodical appearance. Then periodical appearance may be pleased to dispense with the periodical appearance of the petitioner accused in CC number so and so or FIR number so and so, pending disposal of main petition, and thus rendered. These all are the way. I hope you understand these things, and if you still want more clarification, you jump on to Tamil version. There you can be enlightened. I hope that I did not read or stated very fast. I think this is not that much of fast. Okay. Best wishes.